Chairman, this is Erwin Chemerinsky. Can you hear me?
Yes, we can go ahead and go ahead with your testimony. Just remind you have 3 minutes. Thank you. Go ahead.
Of course. Thank you. I apologize for the technical difficulties earlier. My name is Erwin Chemerinsky. I'm Dean and Jesse H. Chopra Distinguished Professor of Law at the University of California, Berkeley School of Law. I've seen and studied the very detrimental effects of Proposition 209. In 1999, I was appointed by Governor Gray Davis to serve on a commission on diversity and outreach in the wake of Proposition 209. In 2004, I chaired a commission in Los Angeles on city contracting that considered these issues. And for the last 12 years, I've been the dean of the University of California Law School. I want to make 3 points. First, Proposition 209 is unnecessary because the United States constitutional law already significantly limits affirmative action. Second, Proposition 209 is undesirable because unlike the United States Constitution, it eliminates affirmative action even when it's necessary to achieve a compelling purpose. It has thus had a devastating effect on diversity and remedying discrimination in California. Finally, Proposition 209 is fundamentally unfair in keeping some, especially people of color and women, from using the political process in the way others can. As to the first point, the Supreme Court repeatedly has held that affirmative action programs must meet strict scrutiny under the Equal Protection Clause of the 14th Amendment. This rigorous test requires that affirmative action programs be shown to be necessary to achieve a compelling interest. In other words, there are already significant limits on affirmative action by government without Prop 209. Second, Proposition 209 goes much further than the United States Constitution in banning affirmative action even when it's necessary to achieve a compelling purpose. The result is to limit remedies for past discrimination and to thwart efforts at diversity. For example, under the United States Constitution, college may use race and sex as one of many factors in admissions, but not in California because of Proposition 209. Study after study shows the underrepresentation of people of color receiving contracts in the government, employment, and education in California. Proposition 209 has had a particularly devastating effect at the University of California. All studies show that minority groups suffer, African Americans, Latinx, Asian American, and Native Americans, when affirmative action is limited. Finally, the effect of Proposition 209 is to keep some groups, especially racial minorities and women, from using the political system in the way all others can. Any other group can appeal to the state legislature or to city councils or county boards of supervisors for beneficial treatment. But those desiring affirmative action are uniquely barred from using the political system. That is why Judge Thelton Henderson declared Proposition 209 to be unconstitutional, though the ruling was overruled by the Ninth Circuit. Proposition 209 is an experiment now for a quarter of a century. It is tremendously harmful for diversity and equality in California. I urge the passage of